Thank you. Whoops. Thanks for having me. Yes, so I'm with the Center for Technology Transfer and Enterprise Creation on campus, right? It's an office under we're in OVPR, so the Office of the Vice President of Research, and we're here as a resource for everyone on campus. So really what we do is manage and license the intellectual property that is owned by Carnegie Mellon University, and we'll jump into what exactly that means. So yeah, I've been with CTEC since 2014, and prior to coming to CMU, I was in an intellectual property firm practicing IP law. So perhaps some of you have worked with my office before, or just been around the creation of intellectual property on campus. So generally, university tech transfer is a part of universities across the globe. And in the US, at least, which I probably like this everywhere, right? It's really rooted in the concept of getting the fruits of often taxpayer funded research of that academic research out to the public, to better society. So while we'll be talking about, protecting intellectual property, and disseminating it. So you can think about while we're going through this, how protecting IP actually helps accomplish this goal. So what, CTEC does. So this is our little infographic, if you're wondering. So intellectual property is created on campus, right, through the research that's being done in all of the labs. So whether it's an invention or code that's being written, that then can be described in an intellectual property disclosure, which is just the documentation of IP that was created at the university. So it's a form, it's online. And so, once that's completed by the creators of the intellectual property, and then submitted to my office, we go through this assessment and evaluation, sort of a triage to understand what the intellectual property is, how it would best be protected, and we will jump into all of these in greater detail as we move down. Does the university own the intellectual property, right? So that's going to be subject to the intellectual property policy on campus. And do any other entities have rights to it? Maybe it was jointly created with a researcher at a different university, or maybe the funding agreement provides some sort of rights to the funder in that scenario. So these are the things that we're doing when we get that IP disclosure form. But we're also thinking about, how does it make sense to best disseminate this intellectual property, again, to benefit the public, and to also, right, this is a conversation with the creators. We're always just talking with our creators. What are your goals for this intellectual property? What do you want to happen with it? And we're there to help guide that and make it happen through managing the IP protection process when it applies, and helping to discuss, hey, are you interested in your own company? Are you going to spin off a company? Do you think there's an existing company that would be interested in this? Do you want to open source? Do you want to provide this under an open license? Let's talk about which ones might achieve your goals the best. So again, we're here as a resource to the community as a whole. So we have to talk about the IP policy a little bit. I don't know if any of you have read it. We've all signed it, right? Because we're all somehow related to the university. So it applies, right, to all of us, to faculty, staff, students. And so when I'm assessing a disclosure, one thing I'm looking at is who owns this intellectual property, and does the university. And so that is governed by the IP policy. It's a very fact-dependent analysis. So the information we have in that disclosure is being used. But really, I'm going to summarize it for you. It really comes down to how the research was funded and what it says in that funding agreement. So whether that funding, right, we have government funding, right, grants, lots more contracts now we're seeing. So that will usually say the university owns the IP. And then, of course, industry funded projects as well. I know we have a lot of master's students, so maybe you don't see this as much necessarily. But that's okay, because right outside of that, the creators, the inventors, the authors typically will then have the first right of ownership. Again, it's a very fact-based analysis. And so this is just a high level summary of how it plays out. But it really comes down to, how was the creation of this intellectual property funded at the university? I don't know. I think we all got the email from the president of the university. There's currently a review board looking into modernizing the IP policy. It's a pretty cumbersome document. I say that because it's not owned by my office. It's actually owned by the faculty senate. So there is a whole review process of the intellectual property policy going on right now. But again, as it exists right now, it applies to all of the intellectual property that's created on campus. And there's also types of intellectual property that the university would not claim ownership to, right? Articles, books, they're actually called traditional rights in academia, these sort of rights. And then as well as things that the creators themselves just decide to place into the public domain. That is sort of antiquated at this point. We tend to use open science, more often than public domain, as public domain truly is legally specific, just opening up, either just publishing and therefore, not being able to be patentable subject matter, or in the copyright domain or copyright law, right? You have to affirmatively state, I am putting this copyrighted work into the public domain on it. Just a heads up if people are interested in that. Our office, though, right, is more than happy, and we work with anybody who's interested, right, in talking about open source licenses, open licenses, Creative Commons licenses, those types of open initiatives. We also now at the university have what's it called? The OSPO, the open source something office within the library. Sorry, I'm blanking on the name of the office. So there's lots of resources for open science at the university. But so that's sort of the administrative portion of of the university side. But we can now dive into to talk about intellectual property itself. So in my opinion, I'm probably biased, but it's important in any technical field to have an understanding of what intellectual property is, how it's protected, and why we protect it. So how all that comes together and what the strategy is with intellectual property. I should say, as we dive in, feel free to raise your hand or ask questions if you want to do a deeper dive on something as we go in here. So what is intellectual property? It is a property right, but they're exclusive rights. So property rights are exclusive rights, right? It's stopping some others from either using or making or copying, right? They're this exclusive right to creations of the mind. So these are intangible property rights. They're granted by the government. But again, you can think of these protections as analogous to a fence around real property because they're very analogous. They are property rights, but it helps to think of them sometimes with respect to real property. In the United States, patents and copyrights are actually constitutional rights. It's right there in Article 1, Section 8, Clause 8, with the intent, right, is to promote science in the arts. So the founders of our country recognize that these rights are tools, right, to be exploited for progress, meaning, they end up being a barrier to entry, which you'll hear me say a lot, for the holders of them. And we'll talk about how they're used, but this runs deep in our society. And again, right, think about that underlying, if we're protecting intellectual property with exclusionary rights, it's interesting to think about that as a tool in order to actually disseminate that information and that technology for the public good. So what are the types of IP? There are different types of intellectual property. So meaning different creations of the mind are protected differently. They're defined differently. They're protected differently. They each have their own body of law around them. So we will go into a deeper dive here on patents, which protect inventions, meaning process, machine, manufacture, and compositions of matter. So that's how that's defined. Where copyrights protect creative works of authorship. So designs, written materials, artwork, and software. So software is property. It's just an interesting example, right? So once software is written, right, that's a written work. So the code itself, as written, is a work of authorship. So it's subject to copyright. Now, what the code does, right, could be patentable as a process or method. So there's an intersection there around software. That's interesting, I think, generally. And then, trade secrets, this protects know-how, and, also inventions. So there's a little overlap here in the subject matter of patents and trade secrets. However, they're quite different, right? Patents, in order to promote the useful arts and sciences, end up published. Trade secrets are kept secret. So that's the main difference there when it comes to what would otherwise be a patentable invention, subject matter wise, but is kept secret. Therefore, patent doesn't apply because that's a process that we will get into. And obviously, right, that would only apply to inventions that cannot be easily reverse engineered. So that's where trade secret would come into play in the world of intellectual property. And then, of course, trademarks and service marks. We all know these quite well because they're in our day-to-day life. And so those really identify the origin of a good or service, right? So this also, not just a barrier to entry, which of course we all know how important branding is. It of course can be a barrier to entry, but there's a consumer protection idea behind trademarks as well. So that's how it's a little bit different than some of the other types of intellectual property. And then, so research materials and data results of research. So again, not a type of intellectual property, but it is a product of research, particularly on campus, and they can be valuable. So to the extent we can apply IP rights to them or sort of treat them the same as we would other types of intellectual property. We do, right? Data itself, not copyrightable, but if it's annotated in a certain way, those annotations, there's copyright there. So that can be, sort of extended to data, which of course is valuable, particularly in this day and age. So why do we care about intellectual property? Again, those exclusive rights means a right to stop others. So there's a monopoly, right? You've created a monopoly here, and that there's value to that. So intellectual property rights are tools to create barriers to entry for competitors. Of course, they're not the only tools around technology, but it's important to have an understanding of how to best use them, and to be strategic. So we'll jump into some of that strategy and context here. I want to put it in context a bit. So once we get into patents, you know why we're talking about these. So in the context of this is medical device development. So through the phases of it, I had to highlight myself the little purple boxes where we're looking at intellectual property, particularly patents in this case. So this is during points of IP consideration during the development of a medical device. In this field, in medical device, there's a patent focus because devices are inventions. But there could also be associated code in all these little purple bubbles here, which would be subject to copyright as well. So if we move left to right through the development phases, in phase one, so the opportunity and risks of the concept. So at this point, when you're looking at those risks, you'd be saying, okay, what intellectual property is available? Doing a due diligence analysis as well. What space are others filing in? Where don't they have fences up, right? Where can you put your fence? And then as you move through the technical development and prototyping, your patent applications are going to reflect what that development is. And then once you get to a product, prior to launching that, you want, obviously, like I said, all patent applications should be filed. But there's also, if you look up in phase 4, there's branding considerations as well. So that's where trademark would come in. So a lot of intellectual property considerations in the context of medical devices. We'll end on a little example of that. But again, we're talking about barriers to entry in this particular field, of the field of, most of you are interested in. If we're talking about medical devices, there's also another big one, and that's regulatory approval and exclusivity. So, if you're thinking of a strategy, companies are certainly strategically planning their IP strategy alongside their regulatory pathway to maximize protection through intellectual property and also market access through regulatory approval. Again, I'm just doing fun little context things. If we're thinking about fundraising, like, how does intellectual property come into play? Well, when valuing a company, property is an asset, right? IP is an asset. It's proprietary, so it can be a key factor in a company valuation, particularly in a new company, where you think, okay, what else is being valued? What is attracting an investor to want to invest in a company? One thing of importance will be the intellectual property. It, of course, is not the only thing. The team is important, right? Being first to market is important. Maybe just being disruptive is important. But I think intellectual property will always come up in that conversation about in fundraising. Even in established companies. Again, it's an asset, therefore there is value in intellectual property because it's a competitive advantage. So it's always going to be a part of strategy in a company. So if we know they're valuable and we know we want them, how do we secure them? And again, that depends on what the intellectual property is. So patents, this is a formal examination process. They're also jurisdictional, right? So it's country by country. Both the examination, the approval, and the grant of rights. So that's a process in the US, right? We have it with the United States Patent and Trademark Office, the USPTO. It ends up being a sort of dance with the patent office. So you file a patent application. The patent office receives it. They assign it to an examiner. The examiner looks at the application. And when we say they're examining it, it means, and we're going to do a deeper dive on this in just a moment. They're looking at it and rejecting it, and maybe you're responding to them. So there's this dance with the patent office. There's a lot of back and forth. They're very specifically written with legally written. So you're working through attorneys. So this whole process is expensive, is what I'm trying to get at there. Copyright, on the other hand, it's actually inherent as soon as it's fixed in a tangible medium, meaning as soon as you paint a painting, copyright exists in it. As soon as you take notes on something, you actually have copyright in that note. There is also the Berne Convention, where at least a large group of countries recognize the copyrights of other countries. So you don't necessarily have this complicated, multi-jurisdictional examination going on in copyrights. They're significantly easier to secure. They can be registered, and you don't have to, but if you do, there are benefits like statutory damages and attorney's fees in the case of infringement. So really, it just increases the damages in an infringement suit if your copyright is federally registered. So one thing to think about software as our fun little example, right? Software is, if copyright is what you're after with it, right, is very inexpensive to protect. So you end up having a higher return on investment because your investment was so low. So they have pretty big margins generally. Trade secrets, technically free, but you just have to keep it a secret, right? There's no examination process because the whole point is to keep it a secret. That tends to be very difficult to maintain secrets. So while free and while valuable, they can be quite difficult to secure and be able to say, you have protected something to the level that it would be considered a trade secret, and therefore somebody misappropriated it. So trademarks and service marks, the United States Patent and Trademark Office, so those can be registered. There is a slight examination process, right, just to make sure nobody else is using it, really. But there are some rights with use, so you can just start using it and establish state-based rights, typically for trademarks. But there's significantly more rights with federal registration, and it's really not that difficult, the examination process, to end up with a trademark. But the interesting thing about trademarks is you have to use them to keep them. So if you're going to maintain a trademark, you have to use it. You cannot just sit on it. Any other type of intellectual property. You don't have to do anything with it. Okay. So we're going to jump into patents here and do a little deeper dive, as I think, they protect devices, and it's probably most relevant to your fields. So patent rights, again, exclude others. They exclude others from making, using, offering for sale, selling, or importing the protected invention. So what they are is a time-limited monopoly granted by the government. They are jurisdictional. So each country has their own system, has their own laws. And the deal to get that monopoly is to detail the invention for the public, meaning so the application and any granted patents are published. You can go on USPTO and all of the patents are on there. All of the applications, even ungranted patents, are available. The USPTO has gotten better, their platform. Google Patents is also very easy to search and find them as well, probably easier than the US Patent Office. And again, right, we need to remember the purpose is to promote the useful arts, to add to the knowledge base of the public overall. So that is actually the exchange. So it's saying, hey, we would like to be considered for this monopoly with our application. And the patent office says, okay, we will consider you for this for this monopoly, but you have to tell the whole public about it. So we'll look into this. You will see how there is a whole description with a patent and an application. So that's the deal there. And if it is patentable, which we'll go through what that means, you get a 20-year monopoly from the government. So what is patentable? We're, by the way, sorry, today we are focusing on US patent law, because that's what I know the best. But most jurisdictions really are similar. There's just some nuances or different verbiage, but similar concepts of what is patentable in each country or jurisdiction, however you want to call it, but they really are country by country. So patents cover inventions, process, machine, manufacture, compositions of matter. But those have to be new and useful inventions. So that is determined by the conditions of patentability. So again, useful, novel, and non-obvious. So novelty and non-obviousness. So these are in light of the prior art. This is a term of art in patent law. So we say prior art. What do we mean by that? We mean everything in the public record relevant to the novelty or non-obviousness prior to the filing of the patent application. So the day you file your patent application, you just set the whole world of prior art. Anything that's published ever prior to that date. Dates are so important in patents because of that filing date, setting the world of prior art for that application, meaning what the examiner can look at when they get your application, right? They can look at all of the existing publications in the world prior to that date when they're going through and examining your application and rejecting it based on it being either not novel or obvious. So those are the sections of law there. And then the 40% frequency, 80% frequency, this is how often they come up in that exchange with the patent office. And how this works, right, is you have submitted your patent application, the examiner has looked at it, they have looked at the world of prior art, and they have said either, no, someone else already did this, it is not novel, And then they write what's called an office action to you, where they explain that and they say, I'm not giving you a patent because of that. Or they say, your invention is obvious. I'm not going to allow this as a patent. And they send you an office action saying that. So what do they mean when they reject it? So usefulness, it's a very low bar, by the way. These are issued patents in the United States, right? So one is a pair of pants with a hole cut out of the bottom. And the one on the right is truly horrifying. This is a device, a medical device, to assist in childbirth by using centrifugal force. So you just spin it around and physics will work. So again, two patent examiners found these things useful. That's not where the rejections come. The rejections come under novelty and obviousness. So novelty, meaning not previously invented by another. And so again, it doesn't exist in the public record. And this is where it gets this is a United States nuance here. Not publicly used or disclosed or on sale for more than 1 year prior to the application being filed, if that use or on sale or disclosure was by the inventor. So there is a 1 year grace period in the United States for the inventors, public disclosures of the invention. Meaning, inventors' public disclosures do end up counting. You can be your own prior art. You can imagine at the university how this comes up a lot, right? As people go to, submit articles and conferences and posters, right? We can be our own prior art. But there is a 1 year grace period from that first date for United States rights. Everywhere else in the world requires absolute novelty. So we couldn't seek patent protection outside of the US if we don't have a patent application filed prior to a disclosure. So that's a key takeaway on that. And then not an obviousness. So the standard here is, would the invention have been obvious to a person of ordinary skill in that field? So really it's looking at the state of the art at the time of filing. How this gets actually plays out in the patent office in that exchange with the examiner is they go, okay, I found, this, or you have A plus B, right? That's your invention. And let's say it's a pen and a cap. And the examiner goes and that finds a piece of prior art that it details a pen. And then they find a piece of prior art that details, just like a chapstick with a cap, right? And they say, well, someone in the field would have thought you could make a cap for a pen. And that's what your invention is. Therefore, it's obvious. So if the examiner says that would be obvious, then you don't get the patent. If the examiner says, no, that wouldn't have been obvious, then you can get the patent. Now, again, in this exchange with the patent office, right, it's a back and forth, right? You get to argue. When they reject it, you get to argue back that they were wrong or maybe change your claims a little, right? So you get to argue that they're wrong. And these are being like, no, this is contrary. This has been it was so obvious someone would have done this earlier. So you do get to argue your point and the back and forth with the patent office. That's one thing that makes the process so expensive. And then there are things that just aren't patentable, right? Some things are not inventions, right? They could be subject to copyright or abstract ideas or nature, right? There are standards in patent law of what you can even apply for. So you can actually be rejected for saying this is not patentable subject matter. This is an invention. Okay. So patents have an anatomy. So again, that detailed description, a specification, and the standard is, again, one of ordinary skill in the art would be able to pick it up, look at it, and say, okay, I can reduce this invention to practice based on what this application says. So that is the standard. Again, right, we're increasing the knowledge of the public. We're that base of knowledge is increasing with every patent application that's published. There's also drawings, and then the claims. The claims are at the end. They're one sentence each, and these are the actual scope of the property right in a patent. So this is the legally protected invention at the end. And so this is what it looks like. I hope that's big enough. So on the left is the front page of a patent. There's a lot of information on the front page of patent. Inventors, owner or assignee, filing date, patent number, application number, abstract, what references were cited. And then there's a long document with all the description and all of the drawings. And then at the end are the claims. This one has 16 claims in it. The first one is blown up here. And so each one is a highly legally crafted sentence. Let's look at this first one that actually defines, again, the metes and bounds, if you think of it as real property, of the invention. So the scope of the invention. The first claim is typically the broadest, maybe the most important, and the actual property right of what you get to exclude someone for. So in this case, Carnegie Mellon University can exclude a device to assist pulmonary function comprising a fiber bundle, a housing, an outlet nozzle, a first gas distribution manifold, and a second gas distribution manifold, right? So that there is a property right there. So that's sort of the scope of property rights and patents. So what is the strategy? So obviously every time costs are taken into account. Typically we expect to pay maybe about $35,000 for a patent application. And again, that's jurisdictional. So the filing, the examination, the grant, and the maintenance of it all have fees, as well as, of course, the attorney's fees that you're paying for to have these all filed, examined, and granted. So having a patent doesn't always mean commercial success, right? It just means it's patentable. So the strategy has to be taken into account. So another thing of patent strategy is, if we're thinking of the value, because we're expending resources, so we should be thinking of the value of putting this fence up. So what does that mean? So there's the scope of the claims. Are the claims broad, meaning your fence covers a big area of property, or are they narrow and it's small, and you could easily work around it, or nobody's going to get that specific anyway, in trying, right? Again, it's a fence, so you're trying to stop people from doing something. The strength of the patent, meaning, would it be hard to invalidate it? The ability to detect infringement is a big one. This is where sometimes the method patents can maybe not be as valuable as a device patent, right? You can say, hey, that's my pen. If for a widget, for a device, you can pick it up and go, nope, it has that. For a method claim, what if it's a method to do something in a lab? Well, you don't know what people are doing in their labs, right? And then even just the obsolescence. So if you're in a fast-moving field where technology changes quickly, do you need a 20-year monopoly, right? This is what I was talking about, sorry, with the, how how strong, what's the claim scope, uh, what is the relative strength of patent claims. And this, of course, isn't a rule, it's just an example, right? So compositions of matter, right? A new pharmaceutical, you can run that through a mass spec and you know exactly if it's the same composition, right? The same with an article of manufacture or machine, right? So you could say, hey, that's my widget, that's my scaffolding. The machine, so the reason it's a little lower, like a 3D print head, well, you know if someone's making it, but how do you know if someone's using it necessarily, right? So you have to think about that. And then so a process or a method, people don't usually open up their labs or their manufacturing facilities, so you know what they're doing. And the reason the improvement is on the bottom is, of course, that there might be background IP that needs to be that you need to have access to in order to even use the improvement. And it's just narrower claim scope. So I just, what is this? Oh, yes. So the analysis. So it's important to make informed decisions, right? When we're talking about spending this sort of money and saying, okay, do we want to put this fence up? Is it worth it? Right. So another thing you can do is a patent landscape analysis, a sort of due diligence. What is already out there? So this, again, these are all public documents. So you can see what others have filed, who has fences around relevant technology. Of course, you'd be looking for space. Oh, I see there's a chat. Apologies. Oh.
Yeah, and I was just about to give you the time check that it's 3:46.
Yeah, I saw it up there too
now.
as well. Thank you. I'm sorry. I know we're covering a lot of ground and I'm moving very fast, but obviously if anybody has questions, please do jump in. But so patent landscape analysis just lets you know what's out there, who has fences up. But right, that also just gives you general information, because there's freedom to operate questions. You can see the trends in a market, maybe, and it can help drive direction of patenting. So I do need to just throw out here licensing because it's what we do, right, as a university. So what is licensing? So ownership, right, or assignment gives the full rights and responsibilities, right? So you get those exclusive rights. But licensing gives partial rights to another. So the rights probably to use that intellectual property. Again, it's a fence, so you can open it to someone. And that's what universities do. So that's what my office does. We license the intellectual property. We do not transfer ownership. If a company comes and wants to use it, right? We license it. And of course, outside of open licenses, there is compensation, right, for that permission to use, either make, use, sell, or for copyrights to copy, display, distribute. So that's just another strategy to keep in mind, right, is that the value of intellectual property, one of it is licensing. And just as a note, at the university, when we do have compensation under our licenses, we share that with our creators. So that's how that works at the university. So that was our patent deep dive. The other types of intellectual property don't really take as long, so we will jump into that and talk about other types of intellectual property and some strategy around that. So copyrights. These cover original works of authorship, including source code, right? But photographs, books, designs, works of art, right? And so the reason it's called copyright is because it's the right to copy. So you think reproduce, adapt, create derivative works is one of those rights. to publish, to perform, to display. In the US, it's significantly longer. So it's typically the life of the author plus 70 years. So way longer than patents, right? Um, and it can also include uh, rights to credit, so we definitely have more of like a moral, there are moral rights and copyrights. We feel a deeper connection to them than say patents and inventions. So there's some other types of rights that are in there with copyrights. Again, it's automatic and you can register them, so that you have more remedies should your work be infringed. So know-how and tacit knowledge. So this is that sort of closely held proprietary information that, just sort of takes years to develop. University licensing often includes know-how and tacit knowledge. You can think how this could be very important for work that's been out of a lab, that's been working on something for a long time. And let's say you spin out a company, right? So that there would be the grant to that know-how in that license, as well as any patents or copyrights or things like that. So trade secrets. So this is information that is not generally known to the public, but has an economic benefit to the holder. But again, it's very hard to maintain the standard that it would take to prove that you tried to maintain its secrecy. But again, it's property. It's common in industry much more than in an academic university setting, right? Our culture is to publish. Our culture is to disseminate. Our culture is not to have everybody signing NDAs like you would at a company, right? And again, incompatible with patents, right? The same invention can't be under a trade secret as it is with a patent, because for the patent, the deal is you have to describe it, no secrets. And then trademarks. Trademarks, we all know these. I feel like this is probably what we're all most familiar with. But again, it's a recognizable, sign, logo, design. It can be a color, it can be a sound. Dolby and all those, they have sounds that are trademarked. And it's really to identify the origin of the product or services. In the US, you can get rights state by state just for using it, but the registration means you have registration across the entire country. So that's sort of the difference and one reason to register a trademark. So in case we've probably seen this, right? So the little TM, that means it's not registered, it's just in use, and it has those rights because of the use of that mark, or it hasn't been granted yet. Whereas the R circle, that means registered trademark, which means the trademark office has approved it and registered it. So okay, this trademark counts across the entire US. You have to use it to maintain it. And something that's kind of interesting about trademarks is they can become generic. And its status can be revoked. So that happened with aspirin, right? That was a trademark, but now we just know it as the medication itself. So they lost it. The same with Zipper. Zipper was a trademark, as opposed to, tooth fastener, right? Which is what we should all probably have called it, but people just called it a zipper, and they ended up losing their trademark. You can think of, do you say facial tissue or do you say pass me a Kleenex? Like, when you say Kleenex, do you actually mean I need that exact brand? Probably not. And so I want to end here with just a fun little example of intellectual property in action. So we have this medical surgical stapling system here from Medtronic, and it has various utility, multiple patents, right, across different countries. One, it has been in licensed, meaning so they had somebody else is the patent owner, and Medtronic had to ask permission to get that license so that they could make this stapler. There's also a design patent on it. We didn't really touch on design patents. They're pretty simple to understand. It's just the ornamental design of something. It has nothing to do with the function, and it's just pictures. You just file drawings with the patent office. They're shorter, they're 14 years, not 20. They have a much narrower scope, but still, Medtronic filed them here. I can see there's three trademarks, right? There's Signia, Medtronic, and then this tri-staple that is also. So if you look at it, it's proprietary staples nestled in a proprietary stapler, right? And there's software that's included, right? I think on how to use it. And then who knows if there is also know-how or trade secrets involved. We don't know. But so that's how IP comes into play. So intellectual property, when we're talking strategy in, one device right there. So it's not typically just like, oh, I have this one patent and that is it. So just my general parting thoughts. The purpose of intellectual property is to create a barrier to entry. In case of actually getting something out into the commercial good, well, that has to be worth it to a company or someone, right? To actually bring something to market. So that's why putting up the fence actually ends up disseminating intellectual property into the public. Yeah, but IP it's one tool that's out there, and I do think it's good to understand. And if anybody has any questions, please, feel free, jump in. I know some of you have been involved in this process because I recognize some names.
Oh, I have a brief funny thing about trademark, which is the Smith Brothers cough drops back in the 1920s. They were like one of the early people to say trademark on their like packaging design, but they had the words trade and mark under the two portraits of the Smith brothers, and so people started calling them Trade and Mark.
That's hilarious.
So I have sent that Wikipedia page to the
Yeah,
chat.
I don't know that one. That's good IP lore right there.
There you go.
I like it. But yeah, anyway. And obviously, if anybody has questions on any of these topics, from the IP policy down generally to IP or disclosing intellectual property on campus, obviously always feel free, please, to reach out. And we can, schedule time to talk about these things.
All right, last call for questions.
No, well,
All
I'll be
right.
around.
Let me quickly pull up what next week's seminar is because I'm getting off track here. Right. Next week is no seminar because it's election day and CMU has that as a holiday. So do not show up. I will not be here to turn you away because I'm actually going to be working the polls this year, so I'm contributing to democracy. Um, and I will see you all back here on November 11th for FDA regulatory pathways with Taylor Goldwest. All right. Thanks, everybody.
Thanks. Bye.
Thanks, Megan.